One of the most frequent questions that I am asked is how much should employers pay on a settlement agreement? And of course, there's no absolute science behind it. The first question that I always ask is what has led you to this point? Because obviously there are lots of different scenarios that may bring you to looking at entering into a settlement agreement. So broadly, there are a few different types of scenarios. So firstly, it may be that there's a disciplinary issue, and during the disciplinary hearing, the employee facing potential dismissal for gross misconduct says, don't want a dismissal on my record, please can we sort something out? Although you're probably feeling okay if it's potential gross misconduct, you might want the finality and certainty that comes with a settlement agreement. Therefore, you might think about offering maybe 1 to 2 weeks pay, or maybe even notice. The best way of thinking about it is think about what are the statutory minimum entitlements that you would have to pay to part company. But of course, with something like gross misconduct, that would only be salary to dismissal plus any accrued holidays. The other thing that can sometimes do it in those scenarios is an agreed reference. Another scenario where you might think about entering into a settlement agreement is where there are performance issues. Now, obviously, if you're going to deal with them, that's going to take some time. So very often parties will say, let's not bother going through the pain of the performance management procedure. Let's agree to part companies now. So one thing that, again, you can think about is what will they get? Would be their notice, their accrued holidays, plus the time taken to go through that performance management procedure, which, depending on the employee and the level of seniority, could be anything from 2 to 4 weeks to 3 to 4 months. The other scenario that you might be thinking about parting company is where it is just not working out. Maybe it's a personality clash, maybe that they're just not the right person for that team, and you might think about again their notice and the holidays which they're entitled to, plus maybe something equivalent to a statutory redundancy payment, or an enhanced if you have a contractual redundancy payment. Again, it depends on how big the issue is and how quick you want to resolve the matter. The other scenario that you might think about parting company is complex, messy cases where it just needs sorting, and it needs sorting quickly. If there's a risk of tribunal proceedings, it's always a really good idea to think about, well, what would be the likely level of award if this person went to tribunal and won, but also factor in commercial costs to the business of dealing with those, plus obviously any legal fees as well that might be incurred, and then maybe apply a risk percentage to take account of the chances of them succeeding. Lastly, you might just need the problem sorted, and therefore it is just about how much you're willing to pay to get the problem off your desk.